We'll call the first case on the docket, 116757, State of Kansas versus Morgan Boschling.
Good morning, Chief Justice Lukert. My name is Randall Hodgkinson, and I'm appearing today on behalf of Morgan Boschling. I request 3 minutes for rebuttal.
3 minutes is granted. Thank you.
Your Honor, this is a criminal case out of Reno County. Mr. Boschling was charged with and prosecuted and convicted of 1 count of burglary, 1 count of theft, and 2 counts of criminal possession of a firearm. Was sentenced to 35 months in prison and granted probation. This case was affirmed by the Court of Appeals and it comes to this court on petition for review. Your Honor, there are 3 issues raised in this case. I'm primarily intending to talk about the first issue. Of course, the court may have other directions for me. The first issue in this case has to do with a jury question and the judge's response to that jury question. In this case, the jury asked, after deliberating some time, can jury nullification apply to counts 3 and 4, which were the criminal possession of a firearm case counts in this case. I don't think I'm wildly speculating in this case. Sometimes I know maybe I wildly speculate, but I don't think I'm wildly speculating in this case to think that the jury was considering this case. The evidence was pretty strong on these criminal possession of a firearm counts. They had pawn tickets from my client having pawned these guns. But I'm told that some people have strong feelings about people's rights to own guns and the government's ability to interfere with that right to own guns. And so I speculate that maybe some people on this jury thought that either never should the government be able to prohibit people from having guns, or the specific circumstances in this case were unjust, where Mr. Boschling went through a legal process and apparently wasn't stopped in getting it, something like that. And so there must have been some debate among jurors saying, well, but the state proved everything beyond a reasonable doubt. And some jurors saying, well, I still don't feel comfortable convicting in this case. And so finally they asked, they're like, well, let's ask the judge. And so the question comes out. And that's why we at least know that there's this question. And the judge's answer in this case was, you took an oath at the beginning of this case to follow the law as given to you in this case. So that's our issue. Our claim is when the jury in this case asked, can jury nullification apply to count 3 and 4? The correct legal answer is yes. That's the correct answer. And if you need more explanation, we have it in cases. Even this court's decision in McClanahan acknowledges that juries have the power to opt to not convict, even in the light of proof beyond a reasonable doubt.
But do we have to overrule other parts of McClanahan to get to the result you asked for?
I think you do not have to overrule the holding of McClanahan, which is, and it was interesting to me to read McClanahan, because it sounds like a really good case when you read it. It sounds really good for defendants, because it's standing for the proposition, I think, that the district court instructs the jury and that the jury is bound by the district court's instructions on the law. And I'm not asking you, and it is not our position, that you have to overrule that, which I think is the core holding of McClanahan.
So you would say the answer of yes is not an instruction to the jury about their right to nullify?
The answer yes would say what McClanahan does recognize, which is yes, you do have the power to acquit notwithstanding proof beyond a reasonable doubt.
But isn't there also language in McClanahan that instructs the court not to inform the jury about that, affirmatively inform the jury about that?
To not give an instruction in the first case about that, and not give an instruction that says that you can do this even disregarding all of the instructions that I've given to you. So, I want to make it really clear, and I know that this court has revisited this question even as recently as this fall. I'm not saying, and it is not my position, that a jury can disregard the law. I think that, for example, when the court says, here are all the elements of the crime, And if the state doesn't prove all of these elements of the crime, I think a jury does not have discretion. They must acquit that defendant. And I, along with the McClanahan court, think that's an important protection for the defendant. So it is not our position, and so that's why I think I am consistent with McClanahan to say that we understand that the jury is bound by the district court's instructions. What I disagree with is the idea that the jury is somehow violating their oath if they opt to exercise their discretion to acquit, notwithstanding proof beyond a reasonable doubt.
Explain that to me. How are they not violating their oath?
Because there is nothing in our law, even in the stingy sort of view of McClanahan, the stingy view of the jury given in the McClanahan decision, even in that case, there is nothing in the law, in the history of the right to a jury trial, that says that a jury has to convict when the state proves their case beyond a reasonable doubt. It says that a jury can convict when the state has proved their case beyond a reasonable doubt, that they can't convict unless the state proves their case beyond a reasonable doubt, but the converse isn't true. And the history of the right to a jury trial bears that out.
How does the answer to the question lead you to your conclusion that they would be violating their oath if they exercised jury nullification? The answer is you took an oath as jurors at the start of this case to follow the law in the case that you were instructed by the case. How does that direct them that they cannot exercise their right to jury nullification?
Because, Your Honor, and again, my speculation is that there is some debate among the jurors as to what they can do and what they can't do. Otherwise, we wouldn't have this question. Right. And so one or more of the jurors said, I think we have the power to acquit, even if the state did prove this beyond reasonable doubt. Some common knowledge of this concept that we call jury nullification.
Not only of the concept, but of the word. I thought that was
of the word.
Remarkable.
They ultimately didn't feel strongly enough about it to do something that they thought the judge would not approve of.
The response, and finally getting to the answer to your question, Justice Rosen, is when they're asked the question, the judge's response is, you took an oath to follow the law. I think the only reasonable interpretation of that answer is the judge saying, if you nullify, you are violating your oath. I think that's the only reasonable implication of that answer. And that's our problem, that they are not violating their oath. They are fulfilling their oath when they exercise their discretion, maybe to decide to not convict, even in light of proof beyond a reasonable doubt. That is an inherent component, and a historical component of the right to a jury trial.
Is there any authority, if I understand it right, you're differentiating for case law purposes between the answer to a jury's question and the original instructions. And you're saying, yes, there are lots of cases saying you can't instruct the jury about nullification, but answering a question is different than instructions. Is there some support for that in the case law?
Well, it's certainly... Let me make sure I get my answer to you right, Judge. So, I don't know if I have a case support. I think the case law support, is that we shouldn't misinform the jury. So, for reasons I don't agree with or understand, I know we have the law that says we won't affirmatively tell the jury the truth about their power. But it does not follow then that we can affirmatively misinform the jury if they ask a direct question like this. And I think the jury in this case, so that's the distinction I would make, is even if it's true that we can't tell the jury the truth at the beginning, I don't think it's appropriate to not tell the jury the truth when they ask a direct question. That if we are going to answer that question, maybe the answer would have been, I can't answer your question. Like, we know that can be the answer sometimes to a jury question, but that's not what the judge in this case did either. The judge in this case answered the question, and I think the only reasonable interpretation of the judge's answer in this case is, if you nullify, you are violating your oath that you took at the beginning of this case.
And you're saying that's not a true statement.
And I'm saying that's not a true statement.
Because it's not a violation of their oath. Maybe within their authority, within their ability to do. But that doesn't mean that they aren't violating their oath by doing it.
I think it does mean that. I think that when we tell juries and when we put a not guilty line on a verdict form and we tell juries, for example, that you do not have to convict just because the state proves the case beyond a reasonable doubt, that means that they are empowered.
They're empowered, but that doesn't mean it's that they're fulfilling their oath by nullifying. There's a difference there. And that's what I'm trying to flesh out. It seems to me we have to hold that interpreting the judge's response the way you've given it, that you'd be violating your oath, that's a violation of that's misinforming on the law. Because he's not talking about their empowerment. He's talking about their oath, and their oath was to follow the law. And they have to ignore the law in order to find your client not guilty if the state is proven beyond a reasonable doubt.
I disagree completely with you, Your Honor. And the history and even McClanahan recognizes that they're not violating the law if they acquit, notwithstanding proof beyond reasonable doubt. They're not violating the law. We can't find them in contempt. If they were violating the law, if they were actually violating their oath, we should be able to find them in contempt, right? That's true for every other violation of a court order. That's true if I violate any other sort of oath. And yet we would never say that about a jury exercising their discretion to acquit, notwithstanding proof beyond a reasonable doubt.
We recognize that they have as I think the words in McClanahan were the raw physical power to nullify. But what McClanahan then said was that when they do that, they are disregarding the law.
Yeah.
And so that's a difference between violating the law and disregarding the law.
So, Your Honor, and it kind of goes back to your question earlier. I mean, are there any parts of McClanahan that maybe, and I don't think that was critical to the holding McClanahan, but to the extent that anything in McClanahan stands for the proposition that they are violating, that a jury is violating their oath by deciding to acquit, notwithstanding proof beyond a reasonable doubt, that is legally incorrect. And it does not bear scrutiny under the history of the right to a jury trial. If that's true, that they are violating their oath, then why can't we punish jurors for doing that? Why don't we take steps to prevent jurors from doing that, like having special verdict forms?
Isn't the reason because the jury room is a black box? I mean, isn't that at least the historical reason? That there's no way to know.
But of course you can know. Judges can ask. Or you could take steps like using special verdict forms to say, you know what, we don't even want you to give a verdict anymore. All you are a fact-finding machine, jury. So we want you to just say, are these facts true? And then I, the judge, as a matter of law, will convict the person. Your job is to find the facts, jury. My job then, as judge, I'll decide whether or not the person's to be convicted. That's not our system. The jury trial right, historically, is a check on the executive, too, on the power even of the prosecutor to decide this case. That's its historical
I
purpose.
guess that's sort of what I'm asking. Hasn't this quirk, I'll call it, you call it a feature of our law, arisen essentially on the grounds that we don't want to know? I mean, we want that check. It is a historical check, but it takes place behind closed doors within the jury room, and the case law seems to me to have developed in such a way to say we want to protect that without it shouldn't come out into the open. That's why we don't tell the jury you can nullify. It's a power that can be exercised, and if it is exercised, there's no remedy. And that seems to me to be a carefully struck balance that you're asking us to upset.
Your Honor, my time's up. Can I answer the Justice's
Yes,
question?
certainly.
So it's not just that. I think you're right, Justice Steele. I mean, in some ways, particularly sort of in the late 1800s to early mid 1900s. I mean, there's this distrust and paranoia about juries, I guess. But when we look historically at it, the idea of the right to a jury trial is much more than just to have them find facts. There's no reason to believe juries are particularly better fact finders than anybody else. But we do have a lot of historical evidence for the idea that the jury is intended and has always been intended to be a final check upon the power of the government, including the prosecutor in a case. That final check by that person's peers to say, should this person be convicted or not, notwithstanding whether the state has proved beyond reasonable doubt. If you wanted to enact things like that, you could do things without even going into the jury room. Use special verdict forms that would do that without going into the jury into the jury room. Or why protect it?
I'm just wondering about what your position. You've thought about this. You're here a lot on these cases, arguing the power to nullify. How is the jury supposed to understand that power without some sort of explanation or instruction about it? And are you a proponent of that, or where do you stand on that, given the questions that my colleague Justice Stiegel just asked?
Sure. It's not this case. I don't have to go to what I would do.
No. I'm just it just seems like if there's this raw power, why should the jury not be aware of that?
Yeah. I think it should. I don't know. For the life of me, I don't understand why we don't tell the jury the truth at the beginning. But even if I'm wrong about that, and I'm not today talking about whether McClanahan's right in the original case in that, what I would say is whatever happens, and this is consistent with Smith-Parker, and it's this principle of non-coercion, is whatever the situation is, a judge shouldn't be interfering in the process of the jury. And so that's what we think in this particular case, the judge's response oversteps that to say, look, I get to tell you what your duty is, and your duty in this case is not to nullify.
Would you be okay would you, in this case, would you have been okay with the judge saying, I cannot answer that question?
It would be better than the answer we got, because it would at least not be coercive.
But would you still be arguing that it's an incorrect statement of the law? Or that it's somehow improper?
It's not, not giving an answer. We'd have to have this. I want to just honestly answer your question. Yeah, I'd still be here arguing that there's a correct answer. But I also have to acknowledge that a lot of the force of my argument today, which has to do with the coerciveness of what the answer that judge gave, would be a lot weaker. My time's way out, Your Honor.
Other questions? Thank you.
Thank you.
Your Honor, Andrew Davidson, appearing on behalf of the state of Kansas. The evidence in this case was pretty strong to show that he was in possession of a firearm and that he was a prohibited person based on that. When the jury came back and asked that question, can nullification be applied to counts 3 and 4? I don't believe that this district court erred in their answer. The answer was meaningful. It described to the jury what the judge had sworn them to do earlier in the trial. And many times during voir dire, questions are asked of a jury whether or not they will follow the law, even if they disagree with that. But there is no premise under the law for a judge to instruct the jury on nullification, and I don't believe that there should be one, because it's one of those things that our courts have upheld consistently, that a district court or a judge or an attorney can discuss nullification in the presence of the jury. That's under McClanahan, and in order to decide this case, applying McClanahan to that, I believe that the judge's answer is correct in this case.
How did it respond
go ahead.
to the question? How did the answer actually respond to the question?
It told the jury what they had been instructed on, and that they had been sworn to follow the law. And so basically they were asking, hey, can we disregard this? And the judge said, well, you took this oath. And so I don't believe that it was coercive. I agree with the panel on the appellate court that the judge is afforded broad discretion. As a matter of fact, the defense attorney at the time of trial didn't object to that response.
Mr. Davidson, if you rephrase the question instead of the one the jury asked to say, does the jury have the power to acquit even if the state has proved the charge beyond a reasonable doubt? What would be the proper answer to that question for the district court?
I believe that the district court should refer the jury back to the instruction of whether or not the I can't remember which pick it is, but it's the pick that says if you have no reasonable doubt as to the truth of the claims, because that's the law, and that's
Well, it says you should find
Yes.
the defendant guilty, not will. So it
and
says
that's
should.
the-
So that-
should
that
is
isn't
a
should
permissive statement.
Right, isn't that permissive?
Yes. And so I think that that's where that comes down.
Haven't we recently approved the use of the word must? Or am I?
No. Smith Parker said no.
Smith Parker said
Will.
must is
Must is
Will.
as
Will.
opposed
Will
to
is-
will. I thought
Yes.
will was.
Smith Parker.
so the state would stand by the nullification is not a right, and there's no ability by the district court to instruct the jury about nullification. There's State v. Naputi, which discusses that fact. But
If the, excuse me, counsel, if the instruction should is okay, which I think you've just acknowledged leaves some wiggle for the jury, then aren't we all just engaged in a pretty elaborate game by not using the word
which word?
nullification? Seems like I have some sympathy, given that we all apparently agree that should is the appropriate way of stating the instruction rather than will or must. Then it's kind of a lot of effort to hide the ball, isn't it? Especially when a jury apparently is already aware of nullification, which strikes me as peculiar.
Sometimes it's discussed, in the media about different cases, but I think that nullification shouldn't be a part of a jury trial process. If the jury wants to completely disregard, like, the law and do what they want to do, they still have the power to do that, but they don't have the ability to be instructed about it.
When they actually ask the question, though, why doesn't the trial judge have the duty to give them an honest answer? You just said they have the
Because-
power. Why shouldn't the trial judge tell them they have the power when they directly ask the question?
Because the case law is pretty clear that it says the judge shouldn't discuss that.
Well, is there any case law that's ever dealt with answering a jury question?
I'm not sure.
Counsel, in State v. Boothby, we recently approved the instruction, your verdict must be founded entirely upon the evidence admitted and the law as given in these instructions. Would it have been appropriate had the judge simply given that or recited that as the answer to the jury's question?
Well, I think that there's probably several ways the judge could answer. This was the answer that was agreed upon by both counsel at this case, when this case was tried to the jury, when they didn't object. And this is what the judge found under his discretion to answer that question. So I think that...
Well, let me ask my question a different way. Is the answer that the judge did give in this case any different from what I just recited from State v. Boothby? Your verdict must be founded entirely on the evidence and law as given in these instructions.
I think that it's similar, just not the same word for word.
Well, your opposing counsel has argued that it has a coercive element to it, and because it references the oath. Does that change the analysis?
I don't believe so. I mean, the
Well,
jury...
why, and why not? I guess, yeah, if you could just directly respond to the defendant's argument that this
That it's...
raising the oath made it coercive.
well, why even give them an oath to begin with? Because you're wanting them to follow the law.
Well, basically you're telling me it is coercive then.
No, I mean, I don't think it is coercive. I think that the answer given reminded the jury of what they had taken earlier in the day.
Is the oath itself coercive and intentionally so? It is, isn't it? The oath itself gives the jury a responsibility, right? It tells them this is what you're supposed to
Yes,
do.
there is a responsibility the citizens of the United States
So
have.
the oath itself is
To
coercive and
listen and-
intentionally so. We want it to be coercive.
Well,
want
we
it
want
to
we want
encourage.
people to follow the law. We want jurors to follow the law.
Right.
And telling the jury to follow the law is not coercive. I mean, they still have the power to do what they want in the end of it, but telling them,
Well, I think the point Justice Byers made is it is coercive. It's just not improperly. I mean,
yeah, I think it's constitutional.
It's
The oath,
intended
but
to-
maybe not just a reference back to
Right.
it. That's where we're trying to cut this extremely fine line. Your opposing counsel, as Justice Stiegel said, suggests that the answer that was given was not only inaccurate, but coercive, because it made reference to this act that we all acknowledge is designed to be coercive. The oath is supposed to coerce cooperation along the lines of using the facts and the law to decide the case and not other extrinsic factors, including your druthers about guns or whatever might have happened in this case.
But I believe that it's lawful for the judge to say that.
I want to ask you about the jury instruction, which we can agree is legally inappropriate, right?
Which
Jury
ju-
instruction on burglary?
With the knowingly element?
Yes.
I don't believe it's error. I think that it didn't impede Mr. Boschling's ability.
The question's whether it's legally inappropriate.
It has a word in there that isn't, I don't believe, in the PIC, but I don't think that it changed the standard based on item number 3 in that instruction, which caused it to have the intentional element.
Well, that's moving over to harmless. But
Yeah.
the first step is whether it was wrong. And it's wrong to put an intent element to a non-specific intent element, which with the entry into the dwelling did not require specific intent.
Yes.
Okay. So by adding that language into the instruction, did that make the state's job of conviction harder? Because it gave the state something more to prove than it needed to prove to get to a conviction.
It might have added a little extra element to burglary that's not there to begin with. I don't believe that I believe it's harmless error and that
It's harmless as to the defendant in your view, but it did impact the state's ability.
well, he was still found guilty.
I understand.
And the evidence supported the conviction.
That's not what he's asking, counsel.
He's asking if it made your job harder because it gave you
Well,
something more to prove.
I think that it may have added something to the charge.
Which makes it harder for the
Yes,
state,
but-
which makes it easier for the defendant, right?
But it also, I don't know how much harder it made it under the factual
Okay,
circumstances.
but what
in
it
this
definitely
case.
didn't do, in your view, is make it harder for the defendant to get an acquittal,
I don't.
if it added to the state's burden.
I don't think so. I just think that the evidence in this case was pretty strong, and that extra word probably didn't make a difference at the end. I have nothing further, Your Honor. Thank you.
Thank you. Mr. Hutchinson?
Your Honor, I just wanted to make it clear, and somewhat in response to your question to my friend Justice Stiegel, that I know the court in Boothby did affirm sort of the oath of jurors that's given out of KSA 60-247, although I did want to just comment on a point that wasn't brought up in Boothby, that the instruction has changed even since McClanahan, or the statute has changed since McClanahan. It says jurors must swear or affirm to try the case conscientiously and return a verdict according to law and the evidence, which is different. Those words are even different than the statute that was applied in McClanahan.
But to follow up on that, do we need to? Boothby just seems like it's a real hurdle for you, and I'm wondering if for you to prevail, would we have to modify or overrule Boothby, particularly, obviously, Syllabus 3, which we've already talked about, approved the instruction, your verdict must be founded on the evidence and the law, and then Syllabus 4 says a district court does not err when it tells a jury to follow the law, and that seems to me to be pretty close to what this district court did.
So there are two reasons that I think it's distinguishable, and I don't think you have to overrule Boothby for the proposition that it has. One is context matters. And it's one thing when you give an instruction at the beginning, like in Boothby and so forth. It's another thing when you respond to a specific question of law with something that doesn't apply to that. And so that's one distinction. And the second point, I guess, I'm sorry if I'm repeating myself, is that it is not against the law for a jury to decide to acquit, even if there's proof beyond a reasonable doubt. That's the false equivalency in McClanahan. If there are any parts of McClanahan that you think about reversing, it's not the overall proposition that juries are bound by the instructions. But, for example, McClanahan says it would be improper for a jury to convict even if they have a reasonable doubt. And that's true. But it is not, the converse is not true.
But doesn't Boothby, again, Boothby might be wrong in this, but it
can't imagine
seems
that.
to me to say that the statement, your verdict must be founded on the evidence and the law as given in these instructions, demands or logically requires the conclusion that nullification is not following the law.
And we would argue that is wrong, based on history, and even based on McClanahan.
So that
says it's
statement,
not
at
violating
least,
the law.
that statement, at least from your perspective, needs to be corrected.
We need to make it clear that it is not against the law for jurors to decide, to opt, to exercise their discretion to acquit, even in the face of proof beyond a reasonable doubt. That's what they're supposed to do. That's their power.
It's their power, but doesn't this really get to the tension in which we talk about this nation is, and we follow is the rule of law, and then you can just ignore. We're allowing jurors to say you can ignore the rule of law and just do what you want to do here, even in spite of all the evidence, proof beyond a reasonable doubt. You can just ignore that. That's the tension as I see it.
That there is some tension. The idea that but that's the nature of a check on the power of the government. At some point, that there is somebody that's authorized to say, even though you prove this beyond a reasonable doubt, we're not going to convict.
So it allows juries to exercise racial bias to do whatever they would like to do.
There are possibilities where this exercise of power could be misused. Just like, for example, we can think about other places where people have a lot of discretion, like prosecutors deciding whether or not to prosecute cases. We would never say to a prosecutor who decides, we would almost never say to a prosecutor who maybe decides for one reason or another not to prosecute a case that you're violating your oath. No, we said you have discretion and you decided to not bring this case. Your Honor, can I have just 30 seconds to respond on the second issue?
Yes.
I just want to make it clear because I'm worried that there's some confusion like there was with the Court of Appeals. Our claim regarding that culpable mental state instruction isn't about the knowing in the elements in part of the instruction. It's that later on in the instruction when the instruction says the crime of burglary has to be proved knowingly. Not the part, and I'm worried that, Justice Bowles, it sounds like you're following what the Court of Appeals did in this case. And the Court of Appeals misconstrued the argument, maybe because it was badly briefed. But the argument here is that the instruction has the elements of burglary, including intent, but then says below that in the instruction, the crime of burglary has to be proved knowingly. And that's incorrect. The crime of burglary has to be proved intentionally because it's a specific intent crime. I just wanted to clarify that before I say it.
Counsel, why doesn't
knowingly appears twice. in the
That's
instruction?
right.
Okay.
But why doesn't this, there was a separate instruction though given on theft. And the instruction said, number 3, that Morgan Boschling did so with the intent to commit a theft therein. And then there was a separate instruction on theft, and that instruction gave the definition of intent.
Yeah, even the burglary instruction, Your Honor, we admitted in the brief, had in the elements instruction that he had to have the intent to commit theft.
Right, but then the jury was also told, here's how you prove theft, which was told to be required for the burglary instruction, and it defined intent there, right?
Yeah.
Correctly.
As far as I remember, I'm focused on the burglary instruction itself. Because the burglary instruction is contradictory, because it says it has to be proved with this intent, but then also the general culpable mental state instruction for burglary says this crime has to be proved knowingly. That's what's legally inappropriate in that instruction. Thank you for your indulgence, Your Honor.
Thank you. Court will take this matter under advisement.